Welcome everyone to today's webinar. My name is Melina Lebona and I'm an attorney at the Climate Law Accelerator, or CLX. CLX is an initiative of Earth Rights Advocacy, which is a program and a clinic in the Center for Human Rights and Global Justice at NYU School of Law. CLX is a global collective hub for research, advocacy, and strategic litigation on the climate emergency. Working with scholars, activists, practitioners from around the world, CLX initiates and supports efforts that build the speed and the scale necessary to spur action within the limited time frame left to avoid triggering scenarios of global warming. As part of this effort, we host regular webinars on timely climate issues. And we also create common goods for the field that you can find in our revamped toolkit, which we will put in the chat. So thank you for joining us today. And thank you to our guest, Ben Franta, who's here to enlighten us today about climate deception and the resulting litigation with a particular focus in the United States. As an introduction, Dr. Franta is a senior research fellow in climate litigation at the Oxford Sustainable Law Program, and he's the founding head of the Climate Litigation Lab. He has engaged with climate change for over a decade. His current research focuses on applying rigorous methods to practical challenges presented by climate litigation. He has been published in Nature Climate Change, The Guardian, and cited in the US Congressional Record, to name a few. Dr. Franta holds a PhD in applied physics from Harvard, a PhD in history of science and JD from Stanford, a master's of science in archaeological science from Oxford, among many other degrees that we would be here all day if we had to list. So thank you so much, everyone, for being here, and thank you, Ben, again, for being here with us today. Before we jump in, I will provide a little bit of context for the audience, and then we can jump in with some questions. So here we go. Taken together, a small cadre of greenhouse gas intensive companies have extensively contributed to physical changes in the Earth's climate while manipulating social and political discourse. Since at least the 1960s, the fossil fuel industry understood that continuous use of their products would increase the concentration of greenhouse gases in the atmosphere, with dangerous and potentially irreversible consequences for the planet. Despite this knowledge, and despite extensive internal research into the risks of climate change, the fossil fuel industry initiated a really well-coordinated campaign of doubt and disinformation to undermine climate science and stave off regulation and legislation that could undercut their profitability. Many of them continue to do this today. So fast forward a few decades, and we're still discovering the gravity of this effort. Indeed, recently unearthed documents show that the oil and car manufacturing industries had intimate involvement in the inception of modern climate science, which of course they later denied. These documents, dating back to 1954, is so far the earliest proof of industry awareness of climate change. In response to this phenomenon, more and more lawsuits are being filed across the world. Today, we will focus on the United States. This is because the US has been a relatively active jurisdiction in this sense, with Chicago filing a case just 3 weeks ago. These cases have been brought by city governments, municipalities, attorney generals against companies like ExxonMobil, BP, Shell, and trade associations like the American Petroleum Institute. Some of these lawsuits have been met with success. This marks a significant stride in a jurisdiction that does not always, or should I say often, champion climate efforts. So now we'll turn it to Ben to give us some insight about this. So Ben, you're a historian, so we'll start with a bit of history. Can you please start by telling us about the fossil fuel industry, long-running, cross-jurisdictional, and skillfully orchestrated campaign to deceive the public about climate change? In doing so, can you give us a bit of an idea about a timeline of key events and some of the key actors that played a role, be that professionals like economists or trade associations?
Thank you so much, Melina, and thanks to everyone for being here. I see some familiar names on the attendee list. It's nice to have you here, and some new ones as well, so it's really nice to have you here as well. Yeah, there's a very interesting history to the fossil fuel industry's awareness about climate change. And, like a lot of other mass tort areas, the history of what the defendants understood about the dangers posed by their products is key to the legal action. If we look at tobacco litigation, that litigation started in the 1950s when the scientific links between smoking and disease were were solidifying or solidified. But it took another 30 years for that litigation to start to be successful. And the key there was to find or have leaked from whistleblowers internal documents from the tobacco industry showing that those companies understood, you know, things about addiction, disease, and so on. That was really the key missing piece. And so, we might think about successful mass torts as requiring three ingredients. One, the scientific evidence of causation. Two, the historical evidence of culpability. And three, the right legal strategies, the right causes of action and so on to fit the situation. Um, I think that now we have all three ingredients with climate, but the historical piece, did not really come about. We didn't really have that historical evidence until very recently, until within the last 10 years. 2015 was a key year in this evidentiary development because that's when the big tranches of internal documents from ExxonMobil, then Exxon back in the 70s and 80s, were discovered and made public. And since then, more and more documents have been discovered. So, in a nutshell, what is this timeline of knowledge and from the kind of development of knowledge from the fossil fuel companies? Well, as Melina, as you said, it goes all the way back to the 1950s. And the 1950s are key because the fact that fossil fuels emitted CO2 was already known. Before then, the fact that there was a greenhouse effect on Earth was known before then. The fact that CO2 is a greenhouse gas was known before then. What wasn't really known until the 1950s was whether CO2 was actually building up in the atmosphere from fossil fuels. This wasn't, kind of a reasonable assumption to make, but no one had been able to measure this. And in the 50s, that's when the first measurements were made of CO2 concentrations in the atmosphere. First, indirectly through tree rings, looking at carbon isotopes and things like that in tree rings, but then eventually directly by the end of the 1950s through that Keeling curve, the beginning of that, which is now a famous curve. It's been going on ever since, these measurements showing directly the accumulation of CO2 in the atmosphere. So that's why we have these early warnings to the fossil fuel industry in the 1950s from scientists, sometimes funded by the industry, interestingly, saying, hey, we did these measurements and this is what we see. We see a buildup of CO2 in the atmosphere in a way that's consistent with what we'd expect from fossil fuel. And it was immediate inference that this would cause global warming. How much and how fast was not yet really understood. There wasn't really a consensus around that yet. But the consensus around that, how fast and how much, was formed by the end of the 1970s with things like the famous Charney report, as it's called, the National Academy of Sciences assessment report about the state of climate science by the end of the 1970s. And so, many of these ingredients of climate science were understood quite a long time ago, and that comes as a shock to many people, myself included, when I first learned about that. So to kind of recap, 1950s kind of earliest awareness that there would be a climate problem, and eminent scientists like Edward Teller, the physicist. If you saw the movie Oppenheimer, you saw the character Edward Teller, who was involved in the creation of the hydrogen bomb and so on. Scientists like that were warning the industry about the eventuality of climate change. Now, it's an interesting legal question of when does knowledge in the field become sufficient to start to peg liability to the industry, some sort of duty to warn or duty to act or something like that. And that's really a legal question, and we all have our answers to that. Personally, I think that should maybe be around 1980, so quite a bit later, just to be sort of fair you know, even to the industry as the science was developing, and I'll explain more about, why that is in a bit, but, you know, 1950s earliest awareness. Now, climate science developed a lot in the 1960s and especially in the 1970s. There was a development of these early computer models where the climate was simulated, and things like the climate sensitivity, which is how sensitive is the Earth's climate to CO2 changes. Consensus was developed around those. And I mentioned that earlier. By the end of the 1970s, there was this consensus around the climate sensitivity that if you doubled CO2 in the atmosphere, you'd get around a 3 degrees Celsius increase in global warming, with a plus or minus, say, a degree and a half, but that central estimate of 3 degrees Celsius, that's pretty consistent with our understanding today. So that was, I guess, uh, over 40 years ago, 45 years ago now. So, that's the end of the 1970s. What else is really relevant in the 1970s is that some of the fossil fuel companies started to create internal research programs on climate by the end of the 70s, especially Exxon. So Exxon's sort of a poster child for this early industry knowledge and how sophisticated it was. There are now many, many documents, and if you go to the UC San Francisco Industry Documents Library, which was created to house tobacco documents from tobacco litigation, they have a section for fossil fuel documents now, and you can peruse those documents. There are over 1,000, I think, at this point, and many of those are from Exxon. So, Exxon had created this internal research program, first trying to see if there was another industry to blame for climate change. Is this being caused by deforestation rather than fossil fuels? And they figured out basically no. Basically, it was fossil fuels causing the problem. And then they wanted to figure out, well, we know the ocean absorbs a lot of CO2, and is it absorbing so much that this isn't really a problem, that it's going to prevent CO2 from building up in the atmosphere? And they found out again, no, it doesn't absorb so much as to prevent CO2 from building up in the atmosphere. So both of the answers they were looking at were bad for them, the scientific questions, and they shut down that research program in the mid 1980s, basically after they found that it was no longer really useful from a business perspective. Now, at the same time they were doing this scientific research, they were monitoring research and public policy being done by others. So they were monitoring research being done by the US universities, the national labs, groups all around the world, and this is attested to in their internal documents. This is Exxon I'm talking about. And they even predicted when would public policy be forthcoming to deal with climate change. And they predicted probably by the end of the 1980s, and they were just about exactly right, because that's when it started. So the industry was on top of this problem. Now, there's one thing I really want to emphasize or maybe highlight here, which is in 1979, there was an internal memo at Exxon that focused on what are the options for avoiding a CO2 buildup. And this is a really key document because it shows that there was a choice, that the industry understood there was a choice, that with immediate or prompt action, the problem could be avoided or at least mitigated a lot. And, the solution identified by the industry was they needed to replace fossil fuels essentially as quickly as possible. And they understood it would take multiple decades for that process to occur. So immediate action was required to avoid the problem, today, basically. Now, that's a really important context for everything that follows, the whole history of denial and delay. The fact that the industry understood that the solution to the problem ultimately was to replace fossil fuel, it kind of simplifies the issue in a sense, and it contextualizes all of the solutions that the industry proposed, which were things other than that and which have not worked to solve the problem. So I just wanted to emphasize that that's really a key point and a key document. And then, finally, I think it's worth saying the industry's predictions were very accurate, and they predicted very precisely how much CO2 we would have in the atmosphere under business as usual conditions, which is essentially matching what we see today, and how much global warming we'd have, and many of the impacts, things like sea level rise and flooding and increased storm activity and droughts. All of those things that we're observing today were predicted in these internal documents by these companies. And just in the last year, a new internal document from Shell has been discovered, and that's another very key document. That one is from 1989, and again, it predicts what the impacts would be, and it showed that Shell understood there were options, that the problem could be avoided or minimized at least. So there's a whole, I don't want to go on too long with one answer, but there is a whole history of, what the industry knew and when, and then their history of denial. And I think just to bring this home, you have this multi-decade history of knowledge, and then by the end of the 1980s, right when Exxon predicted, there was public policy forthcoming. Fossil fuel controls were discussed all around the world. The IPCC was created, the UNFCCC process was developing, and we have an internal document from Exxon. It's a strategy document from 1989 given to the board, and it's all about how to thwart those efforts, how to prevent fossil fuel controls from being effective, the way that controls to deal with ozone depleting chemicals had been effective. And that was the exact comparison made by Exxon in this internal document. It said, look, ozone depleting chemicals, they're being dealt with through the Montreal protocols by the end of the 1980s. How does the industry prevent that from happening with fossil fuels? And that's when the kind of counter movement, the industry's efforts, which were very well organized to defeat fossil fuel controls, that's when they were organized. We know this. We know that plan was distributed to oil companies all around the world, who then implemented that plan in tandem in the early 90s, starting then, to weaken the UNFCCC process and to defeat, European-wide or domestic, like in the U.S. carbon pricing legislation that would control fossil fuels. So that was a very well coordinated effort, and we can talk more about that if you want, but I don't want to go on too long with just one answer. So
Yeah,
thanks.
I think that's great. And this provides great and, as you said, very critical background for the cases we'll be talking about. Just before we move on to the cases themselves, I did want to ask you, could you perhaps in a 1 minute answer, give us a list of some of the strategies that the companies were using in order to deceive the public or hide some of this information? Just an example, some of your literature mentions funding economists, right? Another one that I have seen is sort of placing doubt about as you mentioned, the climate advocacy efforts, particularly when it comes to the UNFCCC, and perhaps implanting their own people in the process to make sure that the UNFCCC process does not make it as far. So can you just give us a brief list of some of those tactics?
Absolutely. I mean, basically, there were three big strategies that the industry pursued, and that they identified as being part of their plan from the very beginning. The first one was the scientific part, emphasize uncertainty in climate science, and in its extreme form, to say we don't know if climate change is happening or not. We need to do more research before we act, and so on. You know, that's maybe kind of familiar to people by now, especially in the 1990s. A lot of the denial was very overt. I mean, you have articles in the Washington Post, for example, from industry, written by industry spokespeople saying, we don't know if climate change is happening, we don't know if it will happen, we don't know if it's caused by fossil fuels, just basic denial of basic climate science. That was the first prong, and I think, kind of infiltrating and influencing the IPCC and things like that is part of that strategy. The second part was the economic part. This was to convince the public and policymakers that it would be too expensive to control fossil fuels and that climate change itself would not be very expensive, that it wouldn't be very costly. And this is what I call the weaponization of economics. And you have people like economic consultants who are hired by the industry. They do studies where the methodology is designed to find this result that it's too expensive, and they just assume that climate change is not very costly. And then those results are presented to the public as if they're independent and authoritative, when in fact they were commissioned by the industry. Now, this might sound kind of incredible that this happens without anyone noticing, but it's been going on basically since the early 1990s, often conducted by the very same people and consulting firms. And just to demonstrate how it's still ongoing, in 2017, when then President Trump pulled the US out of the Paris Climate Agreement, he cited an economic study saying the Paris Agreement would devastate the US economy. And one of the authors of that report had been doing this since 1995 and, had been part of this sort of an original group, and that report too was commissioned by industry. So, this is a strategy that still is going on. And then the third part, which I think is so important, and it's kind of underappreciated, is the false solutions strategy. The industry knew that it couldn't just say no, it had to propose an alternative. And so it found these alternative solutions that would actually protect fossil fuel market share, but they would look like they were addressing the problem of climate change. So they're inadequate solutions or distraction solutions. And the first three identified by the industry, this is 1989, were natural gas efficiency improvements and carbon offsets. So all three of those solutions are still, pretty prominent today. And 35 years ago, the industry identified these precisely as ways to slow down any sort of replacement of fossil fuels and defeat actually effective fossil fuel controls. So that's really interesting. It might be a little uncomfortable in some way because who doesn't like efficiency? A lot of environmental groups have embraced carbon offsets, and much of academia has as well. So, this brings up some kind of uncomfortable questions about, are these solutions being over promoted or misrepresented in terms of their potential effectiveness? Are they actually helping the problem, or are they just distracting from, the replacement of fossil fuels that is necessary? Oh, and I just want to make another point too, which is about carbon capture, because around the year 2000, we see this shift in the industry's strategies away from that overt climate denial and more towards those false solutions, what you'd call greenwashing, basically, today. So we've been in that phase for about 20 years historically, and that's kind of the dominant mode of discourse today. And so around the year 2000, you see the industry saying, we're part of the solution, meaning the industry is the solution. And here's what we propose. Yes, more natural gas, efficiency, carbon offsets. But then they start talking about carbon capture, hydrogen, which is mostly made from natural gas and is an indirect greenhouse gas. Not many people know that. Biofuels, consumer responsibility, kind of blame the consumer, things like that. So it's all of these solutions other than, replacing fossil fuels with renewables. And, we've been in that phase. And what's super interesting, at least on the carbon capture front, because I just want to mention this, is back in 1981, there was an internal document from Exxon that talked about using carbon capture as a solution to climate change. And one, that's interesting because carbon capture already existed as a technology at that time. It's a common misconception that carbon capture is a new technology. In its basic form, it's an old technology. It's been used for a long time for enhanced oil recovery. And, the assessment in Exxon then was it's already too expensive, and it's not really going to get cheaper, and it's just too expensive to be competitive against renewables. And in the last 40 years, of course, renewables have plummeted in cost, while carbon capture has actually remained the same. It has not gone down in cost at all. That's a recent report from some of our colleagues here at Oxford showed that just in the last year. So that's really interesting, and I think there could be more scrutiny over these proposed solutions from the industry, and I think litigation will start to target that as well.
Thank you. That's great. That's a great overview. And I think, as I mentioned, it's so important because many of the phenomena that you talk about actually do make it into litigation, right? So you see these things being litigated and pointed out in cases across the world. So definitely very relevant. So now let's turn to the cases that we'll be talking about. As I mentioned in my brief introduction, local governments in the United States have brought new climate deception cases, right? With Chicago filing their case about 3 weeks ago. So can you give us a bird's eye view typology of these cases and highlight anyone that you think should be important that we should understand?
Sure. Well, I think some of the most interesting cases are these damages and consumer protection cases filed by governmental entities. Now, these aren't the only cases going on. There are lots of kinds of climate litigation, but I think these are really interesting because they mirror other successful mass torts. These are cost recovery actions brought by governmental entities. This is what we saw in the 1990s with tobacco that ended in the Master Settlement Agreement. We saw this with opioids as well. There can be small, well, maybe not smaller, but, private actions, I guess you might call them, brought alongside. So we're seeing like a consumer class action now against Delta for greenwashing based on its carbon offset statements and so on. But I think these cost recovery and consumer protection suits are really powerful and very interesting. So what are these? Basically, you've got municipalities and states seeking damages, monetary damages, to recover for the cost of climate change. And the costs of climate change here include both past actual damages and adaptation costs, and in some cases, future anticipated damages. Now, of course, this is really significant because these damages are huge. I saw a recent report on the impacts of sea level rise in the San Francisco Bay Area, and it was something like over $100 billion in property loss, over the next few decades anticipated. So that's just one area. Other studies have looked at the cost of seawalls across the U.S. and come up with, I think, a $400 billion cost estimate on just seawalls. So the damages here are enormous. I mean, if you aggregate them, they're definitely in the trillions, if not more. And some macroeconomic research has tried to estimate, well, what are the global damages from climate change? And they're coming up with estimates of $100 trillion roughly, and they say, well, maybe the fossil fuel industry should pay for 20 trillion through various dilutions that they go through. But it's a lot, it's tens of trillions, and that's probably an underestimate because whenever we do these local damages assessments, it looks like they're going to add up to be more than the macroeconomic studies indicate. So it's a lot. So that's kind of one prong, is these damages recovery, these cost recovery cases. And then you have the consumer protection cases based on state consumer protection statutes. And what's interesting about these is that these statutes are written very broadly. They prohibit any sort of unfair business practices, and that includes any statements that may be narrowly true, but on the whole misleading. And that's basically what we're seeing from fossil fuel companies today. So, we're seeing them make statements about carbon capture. That's a major thing they're advertising now. And so a great example is, I saw an Exxon ad recently on social media, and it said, we capture more carbon than any other company. And that may be true. So that's an example of a fact that may be narrowly true, but it may be overall misleading, because one, most of that carbon is captured in the process of making natural gas. It's not in order to remove carbon from the atmosphere. It's just making fossil fuel part of that process. Um, but the bigger issue may be that it's just not that much carbon at all. It's tiny compared to the emissions from the company's products. So that's something that I would expect to see litigated. And there's so many there's a big typology question of, you know, how do you sort of categorize all of these misleading statements, and how do you present that legally? How do you present that in briefs, and to a judge and maybe to juries, without making it too complicated, because there are a lot of categories of potentially misleading statements. So anyway, I just want to mention those two, because those are very interesting. And the damages suits, they're based on causes of action like public nuisance, and there's a bit of a debate about whether public nuisance should be broad enough to capture impacts like climate damages. But the consumer protection parts of those actions, those are just based on pretty straightforward, misleading and false advertising laws. And, those are kind of standard. So there's kind of a blend of pushing the envelope, say, legally, and more traditional claims here.
That's great. And just one question, this may be slightly specific, but I want to make sure that we sort of have on the table the different legal basis that you mentioned most of. But so how about the RICO statute and racketeering? Can you briefly talk about that? How has that been used, if
Sure.
successful?
We've seen a few actions bring in RICO. The actions in Puerto Rico have brought those in. RICO is powerful because of things like treble damages provisions, and you can kind of cast a wide net and bring in a lot of different entities into that action, so long as they were, say, aware of what was going on or participated in some way. And that fits the facts here very well, because, again, historically and through these internal documents that have been uncovered, a lot of different entities participated in developing these plans, in consuming those plans and implementing those plans, and creating front groups and coalitions and things like that. The trade associations like the American Petroleum Institute were key in implementing these strategies, and many oil companies and gas companies are part of the American Petroleum Institute and would have been at least aware of what was going on. And so I think it's very interesting that RICO is being brought into this, and just like it was in tobacco. um, and it remains to be seen what will come of that, but I think that sort of claim that, bringing that in fits the facts of this very well historically.
Great, thank you, Ben. And if you had to pick 1 to 2 cases that you think are worth highlighting, I know that there's a couple of very significant cases that are gaining quite a bit of attention in the media, right? From California to Puerto Rico to Hawaii. Can you give us perhaps choose 1 or 2 that you think the audience should know? Difficult question.
It's so hard to pick
You can
one or
say 3 if
two.
you'd
It's
like.
like, it's like so, but there are a few are really significant. I mean, Massachusetts is incredibly important right now. Massachusetts was one of the very first to file, only against Exxon. Is a pretty focused case, and it's not for damages. It's just for consumer and investor protection, and they're moving ahead. That was really heavily litigated. Exxon countersued the Attorney General of Massachusetts, for instance, and lost that effort, but it's moving forward. So I think they're going to be one of the leading cases, kind of in its procedural posture, and so that's very interesting. California, I think, has to be mentioned because it's such a huge economy. It's such a huge entity, um, and they're taking a very leading role. The governor of California and the Attorney General, they're being very outspoken about their case, and sort of publicizing it a lot. So I think that's a really interesting and important case. And then, kind of from a legal perspective, the suits in Hawaii are really important because The oil and gas defendants have just recently, I think it's just in the last week or two, appealed to the Supreme Court, basically on the question of, does can state kind of common law to do with public nuisance and things like that, can that be used to recover climate damages? That's sort of paraphrasing it, but basically that's what the oil companies are asking the Supreme Court to, opine on and decide on. And so that'll be a very important decision, from the Supreme Court. And I guess we'll know that in the next, who knows how long, but year or something like that. And that may clear the way to trial for many of these cases. So those are some important ones to watch.
Thank you. And so many of these cases are going through the discovery process right now, right? And that means that the plaintiffs may be able to go through some corporate records about their disinformation efforts and campaigns. So what do you think is the significance of this? Do you think that there's anything new that you're hoping that the discovery process will uncover?
Well, discovery, of course, is really important, in the U.S. legal system in terms of corporate accountability and just the way the U.S. legal system functions. I think it's it's one of the strengths of the U.S. legal system is that you do have robust discovery possible, and this is why we know so much about the tobacco industry. Um, you know, there are many industries that have concealed what they've understood about their products. I mean, I think one of the most interesting now is the social media industry concealing what it knew about mental health and addiction with regard to social media. That's a really interesting thing. And so US litigation and discovery is kind of how these stories get uncovered and told and how accountability is made possible. With tobacco, something like 10 million documents were produced through discovery, like 100 million pages roughly. So a huge amount, and whole books have been written based on those documents and uncovered, what that industry knew. So, of course, discovery in climate is going to be very important potentially. I mean, we might learn more in the next few years from litigation about the history of climate politics and climate obstruction and climate deception, and basically why we haven't made more progress on climate over the last 30 years than we've learned, in those last 30 years. So this process could be very important, from a justice perspective, from a legal perspective, and also from a public understanding and public accountability perspective as well.
Absolutely, that makes sense. And so let's jump to causation. So one important question going on in these cases is where the company's deception campaign caused or exacerbated the effects of climate change, right? So can you walk us through how the plaintiffs or the court, if there are to reason on this, might establish this causal link?
Yeah, absolutely. I mentioned before there are these three ingredients. You have the culpability, you have the causation, and you have the right legal strategy. And this kind of gets to that causation question of how do you show that an impact was caused by climate change, and how do you figure out how much that cost or how much harm that did, And so there's sort of a growing field. It's not entirely new. It's been around for a little while now, but it's growing quite rapidly now. This climate attribution and impact science that's able to say, this event was made this much more likely because of climate change, and it was made this much more intense or worse, say, because of climate change. And that's going to be really important. Now it's a little bit different from epidemiology. With epidemiology, thinking about, say, lung cancer, someone either has lung cancer or they don't. It's a binary impact. And so, if someone can say, in my opinion, this was more likely than not caused by the tobacco usage, that sort of clears that legal causation threshold. Now, with climate impacts, most of the impacts are not binary. It's not that either this event would have occurred or not. It's that it might have occurred in a less severe way or in a different way. So there's that wrinkle there, and this field of attribution science is able to quantify that as well. It's able to say this heat wave would have been this, this much less bad, if climate change were not an issue. So that's part of it. That's kind of the scientific causation part. And then you have to figure out, well, how much damage did that cause? And you can use things like damage, what they call damage functions, that relate how bad was this impact compared to how much cost did it incur or cause. And that's a developing area too. So there have been some really impressive research articles published in high-profile scientific journals like Nature, Climate Change, and Science lately that have been able to do this. And they say, okay, we know that extreme heat has caused, this much economic damage in this place, since 1990 or in the last 10 years or something like that. And scientists are now able to make these attributions across a wider range of impacts than they could previously. So things like wildfires, public health impacts are a kind of an emerging area as well. So that's all kind of coming into place. And then the last part I'll mention is just the carbon accounting. That's what it's called sometimes, where you try to divvy up responsibility to the defendants. And, you could use like a market share liability theory. Say if one defendant is responsible for 5% of historic emissions, then maybe they pay 5% of the total cost. That's one way, but not the only way. You can also model, how much less costly would this impact be if not for the emissions of that particular company, and you can kind of do that in one fell swoop as well. So there's many different approaches for how to quantify and estimate these damages from the defendants.
That's great. Thank you. And one question that I have for you is, which might not seem obvious if you're not a litigant or a practitioner in this field. So in these lawsuits that are going on, which do tackle the deception, right? So this historical deception by the fossil fuel industry, particularly, how does one tie, for example, that deception by X company to an increased summer, increased heat or sea level rise, whatever that may be, because we see this being done in the cases themselves, right? So someone can point at, well, we had to institute adaptation measures because of our sea level has been rising, and that has been particularly caused by the deception. So can you tie those two phenomenons for us?
Yeah, well, this is like key question. How much worse is climate change because of the defendant's unlawful deception, essentially? And there are, there's no standard way to do this yet. This is a question that I've been looking at for the last few years. One way to approach this is to look at the industry's own projections of how much climate change could have been avoided going into their internal documents. And so we have those sorts of projections from some of the defendants like Exxon and Shell. At the same time, there was peer-reviewed research in the scientific literature starting in the late 1970s that addressed the very same question. So, there's sort of this state-of-the-art expert evidence, there that can say, here's how much we could have avoided if we had done things as we should have, basically, as the defendants had been honest and acted as they could and should have. Now, you can take that and construct counterfactual histories, and this is done in other litigation too. So, in tobacco litigation, this is also one of the approaches taken. If the industry had been honest in the 1950s, then, how many fewer people would have smoked and things like that. So there, the courts have used this sort of reasoning before. But I think, to what degree that will have to be isolated is going to be a legal question. It's sort of a culpability question. I mean, in some cases, for knowing wrongdoing, for knowing harm, if there's scienter about the companies know that they're lying about something and they're, say they're polluting something they shouldn't be in an unlawful way. In some cases, I'm not talking about climate cases, but in analogous cases like, say, polluting a common waterway, the defendant may be held liable for the entire cost, the whole damage, even if their sort of unlawful activity was just a portion of that damage, because they knew they were doing something wrong when they contributed to that. So you know this the answer to this question will depend somewhat on how egregious um, a court finds the behavior of the defendants, and we may see the answer to that.
Okay. And so going on through the process, post cassation into defenses, what are we seeing in terms of defenses, right? I think it's pretty from the sort of at least 20 cases that we have seen in the United States. Some of the most common defenses, because a lot of them do have common defenses, are, for example, free speech defenses, right? But also tactics like attempting to remove the case from state court, where they often begin to federal court in the hopes and where they maybe actually be treated more amicably for the defendants. So can you walk us through the logic and sort of give us a list of these defenses and why might they work or not work?
Absolutely. So many of these defenses are standard industry defenses for these kinds of lawsuits. A common one is the common knowledge defense, and this is sometimes called the chicken soup defense, because everyone knows chicken soup is good for you, but no one has proof. And this is sort of the logic that's used in the common knowledge defense, is the idea that everybody knew about climate change for a very long time, but no one had proof that it's happening or how bad it is until very recently. That's sort of one of the strategies we're seeing. Tobacco industry use this strategy too, saying, back in the 1800s, there are people talking about how bad smoking is for you and things like that, but we just don't have the proof yet that it's there. So this sort of like common knowledge defense, and really logically, what this is creating a very low bar of responsibility for the consumer, while creating a very high bar for responsibility for the producer. And that's basically what's happening here. And so we've seen this being used in the climate cases as well, and that the consumer is responsible for it, but the producers, they're just sort of going along with it, and they're still doing research, and no one's really sure. So, again, this is why the internal documents are so important, because they show directly what the defendants understood at that earlier time. We also see the free speech defense basically arguing that the defendants' communications about climate change were political statements that are protected. I think that's one reason. I mean, basically, that is, there is a lot of protection for political speech. I mean, you can basically lie knowingly to the government, in a lobbying capacity, and not really be liable for it, unless it's part of some sort of, an official proceeding or something like that. So that's very, you know, strongly protected. And I know the contours of that are somewhat contested, but there's strong protections for political speech. But this is why a lot of the lawsuits are focusing on consumer-oriented speech, advertisements, things like that, where the audience, is consumers. And of course, it is on. I mean, generally, I think I'm on safe ground saying it's unlawful to, deceive consumers or lie to consumers about products. That's, generally true across the board. So, that's why that's being focused on there. And then of course we're seeing these arguments that climate change issues in general are preempted by the Clean Air Act, for example. And this is part of this industry strategy to move the cases to federal court, where that preemption is, more likely to be found. But that strategy has not been very successful. It was successful right away when these suits were filed back in 2017, but other than those very few early successes in removing cases and having them dismissed, since then, pretty much all the cases have been remanded back to state courts. So that has not really worked for the defendants overall.
Great. And can you explain, just for those of people in our audience who are not lawyers, what is preemption first? What does that mean? And second, what has the Supreme Court said lately about hearing these cases?
Sure. So, there's this issue of, if you have a federal agency that is already addressing an issue, basically, then, the courts are not going to step in and kind of step on their toes. I mean, that's kind of a rough way of saying it. And that's basically what the industry has been arguing, is that, that there's sort of a kind of federal action or federal regulation through, the EPA or things like that, that is already addressing CO2 and climate change, and that the courts should not really get involved. There's also arguments that this is a political question. There's political question doctrine invoked as well. Um, and that's why the plaintiffs are framing this as this is a state law, issue, and it's not trying to regulate CO2 really. It's about unlawful deception, which is kind of a state law, common law tort issue. And so you have these competing frames of what these cases are actually about and what they're addressing. And you know, again, so far overall, the plaintiffs have been more successful in the courts in terms of how they're framing the case, and that brings us to the Supreme Court. The industry appealed to the Supreme Court, about a year ago maybe, um, on the jurisdictional question of federal and state court. The Supreme Court did not take that appeal, basically, and now the industry is appealing again, more on kind of something closer to the merits of this. And we'll see what happens. It'll be quite important to see, just what the court decides.
Absolutely. And so, okay, we'll have a few minutes, and I encourage anyone in the audience to put your question in the Q&A. So we have a question from Luis Fournier, which actually very much maps onto my last question. So what do you believe the impact of this litigation will be? I was interested in hearing about this both from a legal perspective, but also from a sort of court of public opinion perspective. And Luis is particularly interested in hearing about both the United States, but also internationally, the international perspective. What do you think the impact will be? What are some opportunities and challenges moving forward?
Great question. Thank you, Luis. I think the impacts will be potentially numerous. There is a public narrative impact that should not be underestimated. If we look at, again, tobacco, it's not a perfect analogy, but it's a pretty good one. Um, that litigation established as a social fact that the industry had engaged in this huge campaign to deceive the public for many decades. I mean, that's how that fact was essentially proved, and people just know that now. And you know, people don't really, I mean, some people know that with regard to the fossil fuel industry today, especially if they are kind of specialists in the area, but a lot of people don't. And so these cases, which are based on that evidence, they have an opportunity to really establish that and kind of mainstream that fact, which is well established in the research communities, more broadly. So that is really key. I think from a climate reparations and loss and damage perspective, these cases are also really important because the loss and damage issue has been discussed for a long time internationally with not a lot of progress. But here you have the courts basically going after that, outside of the diplomatic process, which hasn't really succeeded. And so I think, that will probably accelerate the loss and damage conversation all around the world. If this is actually happening in some jurisdiction, it's going to mainstream that notion that that's possible, that that's desirable, that can happen. And so, I think that's going to have some interesting interfacing with that, and what sort of actions will be brought internationally that will seek damages at a significant scale. I think the U.S. litigation could accelerate those cases as well.
Wonderful, thank you. And so we have a few other questions. I'm aware of the time. I have one from Lorenzo Serafinelli, who says, do you feel that EU litigation is less focused on bringing on the surface the science issues? Because both Urgenda and Shell focus on the IPCC and on future damages, less if anything has been said on past conduct.
Yeah, it's a great question. I think that's basically right. I mean, the litigation has a different focus. And, as you know, I imagine in Europe, the focus is more on getting injunctions to compel the defendants to align their activities with the Paris Agreement. And I think this just highlights a kind of legal cultural difference between the US and European legal systems where, I think in the US, and I'd love to hear if anyone, thinks otherwise, I think it would be quite difficult to get an injunction against a company to order it to change its business, basically. I mean, that's quite a specific and far-reaching injunction. And to seek money damages is more of a presumptive form of relief. Now, that's kind of an interesting conversation too, and whether money damages is really an adequate form of relief, or whether that injunctive approach actually would be appropriate in the U.S. as well, I think is an interesting thing to discuss. But in Europe, we're seeing the injunctive approach instead, and I think those are incredibly important cases, for essentially making the climate goals that are already agreed upon and enshrined in things like the Paris Agreement, basically turning those into enforceable law. And that's really what we need. If you think about it from a climate mitigation perspective, that's exactly what we need. So I think it's really incredible that some of those suits in Europe and elsewhere are succeeding on that front.
Wonderful. And so just to top it off in the last minute, a question from Lyubov Velikko. Sorry if I butchered that name. Who are your top 5 influentials, whether individuals or companies, that engage in disinformation?
Okay.
If you can.
Yeah, the Fantastic Five of disinformation. I mean, I don't know if I can choose 5, but it's it's hard to discuss this area without mentioning Exxon. They had a very, very sophisticated understanding of climate change, very early on. Also, because through the historical research, there's evidence that Exxon was a ringleader in organizing the other oil companies to oppose fossil fuel controls and conceal what they knew about climate change and deceive the public. So I think Exxon is, maybe kind of the Philip Morris of this area. But I think the glue in the industry, I think groups like the American Petroleum Institute and even the IPCA, the International Petroleum Industry Environmental Conservation Association, groups like that are really important too. They've played a huge role in helping the industry coordinate its approach globally. So, those are really important. And, I'm sure everyone has their favorite 5, but I think I just saw an interview with Darren Woods from Exxon in the last week where he said, well, it's actually the consumer's fault that we haven't solved climate change. They waited too long to take action, and now there's nothing we can do. I mean, that's a really amazing kind of, blame the victim and point the finger elsewhere approach. And, so that sort of deflection is still going on. And I think part of what's interesting about these cases is they're forcing those companies to have to make that defense and sort of answer for their history and what they're doing today.
Thank you, Ben. Thank you so much. And thank you everyone for listening. We have put on the chat also a chart by Climate Integrity, which actually has a list of the lawsuits that we have been talking about. So because we didn't have insufficient time to delve into the specificities of all of them, if you would like to look at those, feel free to explore the chart. But thank you again, Ben, so much for this very enlightening conversation. And we'll hope to see you soon in another webinar.
Thank you so much, Melina.
Thank you.
Thanks,
Bye-bye.
everyone.